on this seminar. It's always a good place to be amongst friends and colleagues straddling the British and Nigerian legal space. So I want to talk about third-party funding in finance arbitration. I will be honest with you, the finance arbitration bit plays a little part, not very much, because when you're talking about third-party funding, as I'll come to, it's amenable to any type of arbitration dispute, regardless of the subject matter. But I think taking off from where Fadekemi stopped, obviously finance disputes are an increasing breed of arbitration. They usually involve sophisticated claimants who have a CFO who is always looking at the balance sheet. So I think that third-party funding, which, as you see, involves a third party, and again, for definition's sake, I'm not talking here about lawyers financing claims on behalf of their clients. This is not a seminar about discounted rates or contingency fees or conditional fees, which are, of course, a form of third-party funding if you consider lawyers to be third parties. I'm looking at third-party funding where another financial institution actually backs your claim by putting money into the pot and enabling you to fund the claim you're running. So I will very quickly give you an overview of what I will talk about, looking at why I consider funding at all, a look at the funding process, how to navigate it, the growing international market for funding. I'll give you a snapshot of how really important this is and how it's important, I think, in the Nigerian market to be cognizant of it. Trends in the market, again, showing you where the market is going, what the players are doing, what the risks are. And finally, some key considerations for us lawyers to bear in mind if we have the opportunity to look at third-party funding. What are the things we should be looking for in order to protect ourselves and our clients? So some initial considerations. Why funding at all? Now, funding is principally about sharing risk. We find that our clients want to consider third-party funding, not because they can't afford to pay for the litigation, but because they're smart people, they have legal budget constraints, they've fought a piece of litigation to a standstill, case fatigue, they're looking for some investment, maybe for the final push. As I said, their CFOs are involved in the decision. They're looking at the opportunity cost of deploying capital to fight disputes as opposed to building a power plant. It's all about risk allocation and resource allocation. It does allow you to fund and pursue a case which perhaps normally you would not choose to pursue. And you want to offset the risk of a dispute. You want to lay off the risk. You want to bring a third party in to share that risk for you, both in regard to your own costs, but also where you have a cost-shifting jurisdiction, the adverse costs that you may face in the litigation. The types of cases that lend themselves to funding have changed enormously over the last, I suppose, 10, 15 years when funding actually first started in the UK. So you started from single cases, but now you have some quite sophisticated funders who, as I'll come on a little bit to show you, are now looking at litigation and disputes as an asset class. So they will have funders who will set up their own capital, do their own capital raises, and they will go out and fund and look for cases in which to invest in, as you would, say, another sort of private equity fund. You want to back cases that are going to give you a return. So now you have models where you have a portfolio of cases. Funders are spreading their risk, they're hedging their bets. They have some shore bankers in there. They have some that perhaps are not so great, but because of the merits, they can demand a higher share of the payout. So they're quite sophisticated players, and I think that it's going to be an interesting to see how the market develops. I think in Nigeria as well, which I'll come on to in a minute, because it's not entirely clear, particularly where you have Nigeria's seated arbitrations. Now, what is the basic proposition of funding? I think I've already covered some of it. A funder has a pool of money. He wants to make a bet. He examines the case. If he thinks there's a good prospect, and typically they're looking for a prospect of over 55%. Now, you and I and other litigators know that percentages are a 55% chance of winning is 45% of losing. So, so, so it's a statistical game, but they will look to back the strongest cases, and they will seek counsel's opinion. Counsel will usually put a figure on the prospects of success. They will back the case on a non-recourse basis, so they will put the money in, they back the case. If the case fails, they don't get anything back. So that means that they have to be very careful about the cases which they choose. Success can be defined in a number of ways. Obviously, from a funder's positions, the best success is where you've actually got some money back from your defendant. But typically, success is a bit of a hybrid. Success is defined as a favorable final award, but you won't get paid as a funder until there's a recovery made. And typically, the recovery will be capped at the recovered amount. Some funders will try and slip past you that success means an award and they get paid out regardless of whether or not you make a recovery. So it's something to be alive to, but the market standard is usually linked to what you recover on enforcement. So just a quick canter through the position in the Nigerian market. The position in the UK is well settled. There's been a liberalization of funding. The rules of maintenance and champity essentially are dead, and third parties, lawyers, as well as providers of cash can actively participate in the proceeds of litigation. So that's clear. In Nigeria, it's not so clear, particularly as regards arbitration. So there was the Arbitration and Conciliation Act, Repeal and Enactment Bill 2017, which is making its way through the legislative institutions at the moment. The Senate passed the act, passed the bill, I should say, last year, and it's pending before the House of Reps. That act implicitly recognizes third-party funding in arbitration. It defines costs to include third-party funding, and it empowers tribunals to fix the cost of arbitration. And the costs include third-party funding. It defines third-party funding, an arrangement between an individual or corporate entity and a party involved in the litigation, whereby the funder agrees to finance some or all of the third parties, of the party's legal fees in exchange for remuneration from proceeds of the award. So all the ingredients are there, except that there isn't actually an explicit, express statement that that third-party funding is permitted. So it's got all the implicit recognition in the bill, but that last mile to say, and Nigerian law overrides the common law of champity and maintenance to allow a third party to come in to fund litigation. There's quite a bit of debate, and I can give you references if you wish about some pretty scholarly articles on this whole debate about whether the bill will go far enough. The best, the weight of opinion is that it doesn't, because I think Nigerian law is quite clear that where there's a conflict between statute and common law, then statute overrides, but it's got to be pretty clear, and the statement in the bill doesn't go far enough. So very quickly, let me talk a little bit more about the funding process and how you go about it. If you have a claimant, you're acting for a claimant who has an arbitration with a seat in a jurisdiction that does allow third-party funding, or you have an arbitration which is governed by English law, and it is operating on the aegis of an institution whose cost rules or gives the arbitrator discretion to award the costs of third-party funding. How would you go about looking for a funder? There are a number of ways you can go about it. The best way, particularly if you're new in the market, is to look for a broker in the same way you would go to a broker to get the best insurance. There are a number of brokers in the market who will guide you in the right direction, and they will see the entire field and be able to get you something that approaches your tailored requirement. When do you make the approach? Obviously, if you've got a well-developed case and you can persuade the funder that this is a good case to be backed, then you can move very, very quickly. Some funders want to be involved right from the start. They want to see, they want to be involved in instructing counsel to give an opinion. Most of them require counsel's opinion. They want to see some draft pleadings. They want to know who your witnesses are. They want to know some settlement prospects. You might want to develop a lot of this yourself because it puts you in a better position to negotiate against a funder. But there's also a trick to it, because if you have a funder on board and you let the other side know, they consider you're serious about this, and it might actually focus the defendant's minds on a settlement. So there's an art to it. You need to check with yourself and with your client how much the client wishes to move the risk of litigation to a funder. Do you want to slice it up? Do you want to take just solicitors' fees? Do you want to take counsel's fees? Do you want to go for experts? What bit of the risk do you want to lay off? I've mentioned earlier that the best way to share risk is not just third-party funding. As a law firm, are you prepared to share some of that risk? Do you want to go for a damages-based funding arrangement where you look for the upside you want to recover? That area is much clearer in Nigeria in terms of what is allowed and what's not. Where funders are quite clever is being able to use models to show what might happen in different scenarios. Very quickly, with the due diligence process, the economics need to work. That's fundamental. A funder will not back a case where the economics don't work. Typically, we're looking for costs to recovery of a ratio of 1 to 10. Very simply, if you have a claim worth £10 million, they will want to see costs limited to £1 million. Because if it's more than that, it doesn't work. And it doesn't work because they will typically look for the equivalent of 3 times funding, or 35% of recovery. Now, if the solicitor's costs are more than £1 million in that case, the recovery which the funder makes will wipe out much of the damages which which could be recovered. So there's a fine balance between getting your economics right and the funding that will be available to you. I know that time is pressing on, so I'll move through the slides a little bit quicker. These slides will be available presumably about, yes. And I can follow up with my notes if you want to take a look at some of the more detailed references. So there's a great international market. There are big funds. I've talked about Berthman being a good example. Has an investment portfolio of $3.2 billion. It's invested in litigation to the tune of $3.2 billion. You have big hitters in the UK, but you have smaller players who are more niche, maybe back typical certain types of investment of arbitrations, finance arbitrations, tech arbitrations, third emerging market arbitrations where there's a certain skill to making recoveries. So there's a big field to choose from if you do have a case that fits the bill. I've talked about trends in funding a little bit. There are more players. That hasn't necessarily reflected in lower pricing. As I've said, typically they're looking for a return of 3 times their investment. If they back a case to the tune of 1 million, they want to recover 3 million. So in your $10 million case, they want 3 million out of the 10 million. Now, as I said, if the costs are actually 2 million and they want 3 times that, out of a $10 million pot, they're recovering 6 million. And they will be happy with that, but that leaves the claimant with 4 million, and they simply won't go near it. So that's where the pricing comes in. I mentioned disputes as a, sorry about this, it seems to be very sensitive to touch. Disputes are developing as an asset class, which adds to the attractiveness of it. And I'll finish very quickly on some key considerations for lawyers. First and foremost, do not forget your duty is to your client. Your duty is to ensure that you represent the best interest of your client, funding or no funding. And of course, the moment you let a third party in, it creates all sorts of conflicts. Whose interests are best served when a settlement offer is made and the funder wants to cash out or your client wishes to pursue the litigation. That's why any funding needs to be carefully negotiated, carefully memorialized in an agreement, so you know exactly where you stand. But increasingly, we find that one of the first questions our client will ask is, I've got this great claim, how do I fund it? How do I defray the risk of this? Which is why I think, particularly in a market like Nigeria, where it's just growing, just starting, those lawyers who can steal a march by researching what's available, looking at the uncertainty around the Nigerian law position, getting themselves comfortable with what could be amenable to third-party funding, I think you will have a huge advantage. We in the UK are under an obligation to advise our clients about all available funding options open. So we have no choice. And if you don't, it's a professional standards issue. Get to know the market. Start to know those funders who will play in the Nigerian market, and there's some of them. And I'll be happy to put you in touch with our own funding experts in-house if you want to learn more about those funders who might be prepared to look at funding claims arising out of Nigeria. Understanding how the funders work is fundamental. So that's me in a nutshell. I've probably exceeded my slot by a few minutes, but I hope you don't mind. It's an exciting development. I think it gives litigators real firepower to play in the boardrooms. As I said, the CFOs are very interested in this because for them, it saves them a lot of grief if somebody else is carrying the can. So I would suggest that you do get more comfortable with the prospect. And I'm happy to take questions and further guidance at the end. Thank you very much.